Hey everyone, it's Rob Ryder on Friday, June 7th, 2013. This seems like a pretty big deal, this next video here, so please pay attention, especially if you got a court case going on. I'm not really at a point to say, okay, do it this way. I just want to point out what it says, and that really we're our own biggest problem because we try to make things much more difficult than it needs to be. So this is an email that I had sent out today, but because not everybody gets my emails, I thought I'd just read it. So, folks have been told in court, you need to follow procedure. Okay, let's do it. And file a motion for show cause hearing, which is really a contempt of court hearing. We have no shortage of evidence, and because the type of contempt they are guilty of is considered indirect, the procedure requires that a motion for a show cause hearing is entered. So, it isn't that they're not in contempt of court. It's considered indirect contempt, and you need to bring it to the court's decision, or to the court's to the court's conscience, right? So the court's attention, that's what I was trying to say. And there's no shortage of evidence, because one of the things that we're going to have to do is put in an affidavit. Well, we've been writing complaints for some time now that point out the evidence of their misdeeds, and I really believe if you have done the DBA, doing business as, or just made up an affidavit that says that all caps is your property, right, and your true name is this name and you are the owner, because that's really what the DBA does. And then you get a certificate that is under the seal of a court of record government body that agrees with you that all caps is a business and your name is, in my case, Ritluski, Robert Allen. That's my true name. You want to summons me, that's how you summons me. All caps is the legal name. Your full name is like all caps, but it's upper lowercase, but your true name is your surname coupled with your given name, Ritluski, Robert Allen. Okay, so below I've gotten most of this out. Well, I got all of it out of the two different books, Michigan Circuit Court Bench Book and the Contempt of Court Bench Book, 4th edition. Now look, at this stuff is easy enough to find online. You don't have to ask me where to find it, right? You just Google the stuff. So this, Circuit Court Bench Book, whatever the name of your state is, whatever the name of the court is. Circuit Court here in Michigan is the trial court. So whatever your trial court is, and you can find a bench book. And, it covers contempt. One of the many things it covers. But that wasn't enough. They wrote another book just on contempt. Contempt of Court Bench Book, 4th edition. Right? So if you Googled either of those, you'd find it for Michigan. You're going to have to find your own. Or you can look at Michigan's, because it's really going to be the same. All we're doing is trying to figure out the proper way to do the procedure. And so we can read these books till we're scratching our head. Or if you have a court case going and there's free legal advice someplace, well, go ask an attorney how you file a motion for contempt of court or for a show cause hearing. I would call it a show cause hearing. And what normally happens is when we go to talk to these people, they ended up asking us the questions instead of us asking the questions. And so if you went to see one of these guys and said, you want to know the proper procedure for filing a show cause, for a motion for show cause, they're going to probably want to know what it's for. You say, well, that's not really the question. Yeah, what I want you to tell me is, can you tell me the proper procedure for filing for a show cause hearing? And get that out of the way first. Then if you want us to know what it's for, after that, you can show them your affidavit. Now, I want to submit this affidavit with it. And, but at least you will know the proper procedure for doing a show cause. And beyond that, there's some pretty smart motherfuckers out there that are going to figure this out over the weekend, and Monday we could have an answer. I'm just not an expert at putting paperwork into court by a long shot, but I can read what it says to do, and this is as simple as a properly motion for show cause hearing, given evidence and proper notice, and then the court will do the rest. So, for instance, this was in Virginia, right? One of the things was, this is what Handcuffed John got from the magistrate office, located in the basement of the courthouse and complex inside the sheriff's office. Go figure. In addition, magistrates assist the public by providing general information on civil and criminal process and procedures. Go ask a magistrate how you properly file for a show cause hearing, because it's called ex parte motion. And ex parte usually means the other party isn't being noticed. I watched a video the other day that, one of the other things about ex parte is it won't necessarily show up in the docket that it ever happened. More on that in another video, but my point is, right, you want to know how to do it? Go ask somebody who knows. And then come back and tell me what they told you. Right? Beautiful. Show me how they showed you to complete the form. And we'll put it on a video and we can all learn from it. Alright, so I don't need that one anymore either. Yeah, save them. Okay, so I'm still researching and reading them myself, but I know there are many who understand the courts and could use this information today. I'm not ready to answer a lot of questions, just point out what is said and why you might want to start your own research today. Right? Don't call me, go read the book. And don't read it once, read it 3-4 times. Man, I read this shit over and over and over again. Right? You're not going to get it the first time. Or you're going to read it too fast. People think it's the number of pages they read that's important. I'd rather read one page all day and understand it completely than read 100 pages and have no idea what it said, even though I think I do. Okay, so I'm not ready to answer any questions. It comes down to doing just one thing correct. File a proper motion with verified affidavit, giving proper notice. Okay, it's a trinity of one thing. If I had to do it today, I'd file against the attorney of record, as he is one you have an address for, right? Because you're supposed to send everything to do about the case to the attorney. The plaintiff is a fiction, and so is the defendant, but the attorney is on record as one, is an officer of the court, always considered in court, and it's time he was sent back to the fleet. And as I remember, send him back to the fleet comes out of Lord Coke, where he's talking about courts of request, the court of request. And really, when I'm thinking about it here, it's like, that is what a motion court is, right? It's a court of request. You're motioning for something to happen. And that's where he was talking about pointing out the attorney's misdeed, and he's going to go back to the fleet. 30 days in the brig and back to the fleet. Contempt of court. Well, how do you do it? Well, statutory provisions illustrating use of courts' contempt powers. The Supreme Court, Circuit Court, and all other courts of record have power to punish by fine or imprisonment, or both, persons guilty of any neglect, violation of duty, or misconduct in all the following cases. I just picked out the ones that spoke to me, which is all attorneys, counselors, clerks, registrars, sheriffs, coroners, and all other persons in any manner elected or appointed to perform any judicial or ministerial services, right? Because you have judicial magistrates and you have ministerial magistrates or administrative magistrates. Anybody, for any misbehavior in their office or trust, or for any willful neglect or violation of duty, for disobedience of any process of the court, or any lawful order of the court. There's only one kind of order. It's lawful, or it's not an order. Or any lawful order of a judge, of the court, of any, or of any officer authorized to perform the duties of the judge. Okay. So all attorneys, counselors, clerks, registrars, sheriffs, coroners, and all other persons in any manner elected or appointed have a problem if they put in a willfully false statement. So, parties to actions for putting in fictitious bail or sureties, or for any deceit or abuse of the process or proceedings of the court. There is no sworn complaint from the plaintiff. That's deceit. Trying to say that your deed of trust is a contract that you're lawfully required to uphold when they didn't sign the damn thing, because any agreement between two companies, all caps and the bank, both parties have to sign it, or you don't have a contract. There can't be a debt. Parties to actions, attorneys, counselors, and all other persons for disobeying any lawful order, decree, or process of court. All persons for assuming to be and acting as officers, attorneys, or counselors of any court without authority. So by what authority do you bring this charge? That can be your show cause hearing. By what authority does this attorney bring this charge? That's all you'd have to put on the first go around. And now they have to show by what authority they're bringing the charge. They can't show why they're bringing the charge. It's a malicious prosecution. 30 days in a brig, back to the fleet. All other cases where attachments and proceedings, as for contempt, have been usually adopted and practiced in our courts of record to enforce the civil remedies of any party or to protect the rights of any party. And this goes back to, to enforce the civil remedies. And I don't remember what video I did here in the last couple of months. It was in a definition where it talked about if you wanted a civil remedy, you had to point out the transgression. That's what you're doing by putting in a show cause motion for contempt of court. Contempt powers of quasi-judicial officers. Some MCL, Michigan Compiled Law, states that judges may fine persons in contempt for disobeying the lawful orders of any officer authorized to perform the duties of the judge. So first of all, it's the judge who can fine you in contempt for not following his order from an officer authorized to enforce his orders. So if you're in court today, ask the judge if he has the power to fine someone in contempt. If not, then he ain't a judge, and he doesn't have the power from the judge. You say, well, then you better recuse yourself and find me somebody who can. I want somebody who can fine someone in contempt because I want to file them. I move the court for a show cause hearing for contempt of court. Under these provisions, any officer of the court of record who is empowered to receive evidence and any referees or auditors appointed according to the law to hear any cause or matter may recommend that the judge punish as contempt of court the disobedience of a subpoena. So they're talking about a lawful order in here, right? What's a lawful order? A subpoena is. The shit you're sending you isn't a subpoena. It's not even under a judicial seal. It's from a clerk. You could really only be found in contempt for not following a lawful order, and a lawful order would be by subpoena. So another thing to ask judge, are there any lawful orders that have been entered into this case, judge? I don't believe I've ever received a subpoena. An excellent summary of the law and procedure governing contempt is found in Contempt of Dzerzhinsky, 257 Michigan, App 96, right? Google it, look it up if you want. What is indirect contempt? Outside the presence of a court. If the contempt is committed outside the immediate view and presence of the court, it is not subject to summary punishment, and the appropriate process is a show cause hearing. And the way they have it set up, everything they're doing to us is really indirect, not within the view of the court, because you're not in the circuit court. You're in an administrative court. The circuit court may punish by fine or imprisonment, or both, parties to actions, attorneys, counselors, and all other persons for disobeying any lawful order, decree, or process of the court. Now, the process of the circuit court, not the fiction court, the real circuit court. The circuit court for the county of Kent, the circuit court for the county of Alpena, the circuit court for the county of Montcalm. That circuit court. Non-party individuals who are responsible for the misconduct of a contempt nor corporation's affairs may be sanctioned for the contempt of the corporation. So even though they're not involved personally, because the corporation is, they are. Michigan Court Rule 3.606 sets out contempt procedures for the alleged contempt committed outside the presence of the court. Okay, if you thoroughly understand Michigan Court Rule 3.606, you're ready to go to put in a motion for a show cause hearing, which is a contempt hearing. But it's an ex parte motion supported by an affidavit of facts, your complaint under oath, requesting an order to show cause is required to bring the matter before the court. You have to ask by motion. The order to show cause must be personally served unless the court orders otherwise. In addition, the court can issue a bench warrant. Beautiful. All contempt proceedings are considered quasi-criminal or criminal in nature. The rules of evidence, other than those with respect to privileges, apply except when contempt is summarily punished. MRE, I don't know what MRE, Michigan, something. I've never looked at the MREs. But there is one about, oh, that's the rules of evidence, Michigan rules of evidence. I have looked at it, actually. Civil contempt is coercive and intended to compel the offending person to take some action of which he or she is capable to purge the contempt. It is prospective, looking for, we put some pressure on the dude, to make him do the right thing. Such as, if you've brought this case, if it's not a malicious prosecution, then you need to file a sworn complaint. If you don't file a sworn complaint, it is a malicious prosecution. As an officer of the court, the attorney has just brought fraud upon the court, and the court will handle it from there. It's just indirect, and you haven't brought it to their attention yet. Because civil contempt actions are tried by the court without a jury, the court must make findings of fact, state its conclusions of law, and direct entry of appropriate judgment. So, the court they're talking about is the lowercase circuit court. Right? So I think that when you address these, it's in Michigan, it's in the circuit court for the county of whatever it is. That is appears to be the proper address for the de jure court. It could even go further and say, and probably should, in the circuit court for the county of Kent, comma, in Chancery. What is criminal contempt? Punishes past conduct and is punitive. So if you already have been charged in a case, you can still file for contempt. With criminal contempt, the accused has the due process right that apply to a criminal defendant except when there is no jury or no right to a jury trial. Except there is no right to a jury trial. Jury isn't going to be involved. It's going to be the trier of the fact that's going to make the decision. So you could file a motion into a case that's happened in the past. If you can write yourself a halfway decent affidavit, properly file the motion, notice the parties. How do we do that? We go ask the people that know. Go find that free legal advice and ask them how you do a show cause hearing. In a criminal proceeding, the standard of proof is beyond a reasonable doubt. All of the evidence will already be in the court case because there isn't anything under judicial seal. Well, there may be at the end. However, there's errors and omissions on the paperwork, and if they won't correct the error or omission and it's pointed out, then that's deceit on a procedure. Right? If you give them something to answer and they don't answer, well, they're technically in contempt of court, but you need to point it out. Say they didn't answer my complaint. Punishment. 3 kinds of sanctions are available to redress to contemnor's behavior. Civil coercion to force compliance with an order, criminal punishment to vindicate the court's authority, and civil compensatory relief for the complainant. In other words, right, you can make a claim upon which relief can be granted, and the court can compensate you for your damage. And this is, there was procedures and sanctions for common forms of contempt. The following table indicates, this is a whole long table. Acts described in Chapter 5 constitute direct or indirect. So it tells you which type it is. So filing of false pleadings and documents, and that is what they do, right, is always indirect contempt. It's their paperwork that is the falsehood, right? It's a false pleading, false document. It isn't what it appears to be. The promissory note isn't a promissory note. The promissory note that they want to think you is a promissory note is actually a security, because it matures greater than 9 months. 15 U.S.C. 78 C10. Definition of a security. Any note that matures in more than 9 months. Right? They ask you on the deed of trust, is that your signature? Sure it is. Where's the bank signature? This, where I signed, it says this is a security agreement. Well, if it's an agreement, both parties had to sign. Beyond that, I have a certificate of ownership under the seal of a court of record that they agree that All Caps is a business, and my true name is Rytlewski, Robert Allen, and since we appear to be in an in rem jurisdiction, well, in rem you have to have properly noticed the owner, and you have never properly noticed Rytlewski, Robert Allen of the hearing. You've never gotten proper notice in your true name. That's the importance of the true name. I can't stress it enough. But anyways, that's what the form looks like that they talk about using. Motion and order to show cause. They're good enough to put it all on one. I'm going to use their form, right? And here's the reason. This form has been approved by the court. All we need to do is make sure that we fill it out correctly. And so you see here where it says court address. I don't think that that's the street address. It didn't say court street address, court mailing address. It's how do you address the court. And I think in here is where you would put in the circuit court for the county of, in and for the county of Kent, in Chancery. And everything is lowercase except the K on Kent. The plaintiff, petitioners, right? So you're going to be the petitioner. They're going to be the respondent. In the matter of, I don't think we need to check probate or juvenile. Although we could, right? Because one of the things we're trying to get is an ex parte hearing, a property hearing, to determine who the owner is of all of our property. And that's just proving your birth documents, proving by giving them proof that you have this certificate of ownership for the business. The court should be able to give you an order to get your property. It wouldn't be on this. This is a show cause, but that's a different petition. This is strictly for if you got a court case going right now. So I am interested in this matter as owner of the disputed property. Whoever, right? Put the attorney's name in here. Is in contempt for filing fictitious and fraudulent documents. State the particular admissible facts establishing this motion, right? So this is where the affidavit stuff comes in. If you could get it into that thing right there, right? This one thing, I think, could act as your whole piece of paper. Everything you needed to do. Because, as you can see, you're going to subscribe and sworn before me, right? So if you can fit your affidavit statement under 2, this one form can do everything because it's the motion and affidavit. Or you may have to say, see attached affidavit of fact, see attached sworn complaint, whatever you think you need to do. Okay, and what do you request an order directing somebody to show cause why, right, he or she should not be found in contempt. Well, contempt is if it's criminal is for if it's already happened, a past event. Civil sounds like it's something that's still going on, and if you're in a court case now still going on, it's civil. If it's already happened, it's criminal. A judgment should not be entered against him or her. This is why a judgment should not be entered against him or her as surety agent for the full amount of recognizance. I check that box too. Judgment should not be entered against him or her for failure to file garnishee disclosure. I don't know if I need that one. I'm going to take A and B. This affidavit is made on my personal knowledge, and it is, if sworn as a witness, I can testify competently to the facts in this motion and affidavit. Sure you can. Subscribed and sworn before me. And then this is the notary stuff, and then boom, now we go to the order. 2. See, like what goes in this box, right? Are we supposed to fill this out, or does the court do that? I don't know who does it. That's why I want to ask somebody who knows. How do I fill that out? It is ordered you must appear before this court on some date, time, court address above, courtroom number, or check this, they're going to tell them where to show cause why. So this is the order, right? And there's the proof of service. Acknowledgement of service, certificate of mailing, everything on a 2-page form that you need to file a motion and order to show cause. And just, we've been trying to get our complaints in so they see them, and they say, well, you got to follow procedures, and it has to be by motion. Well, here it is, motion and order to show cause, because we want to find them in contempt. They brought the charge, it's a malicious prosecution, it's done, it's a simulated legal process, all the things that been yakking about before are true. It is what it is. It's just how do we get them to recognize it? And it isn't that hard. It's a 2-page form, and it's not that it's been hidden, it's in the fucking bench book. Hell, they wrote a whole book on just contempt of court, for God's sakes. So we can't blame them for us not paying attention. And now that, you know, if you think this means something and you go to read the shit, then fucking pay attention to what it says. Don't read it once and call me and ask me a question, right? Read it all week. Go ask an expert. You want the experts? Free legal advice. Find out how you have it in your county and go ask them how you'd fill this fucking form out. When you get that done, you're going to get a remedy. That's all I can tell you. It's the way it looks to me. Okay, I got to read it more myself and get into the finer details, but in a nutshell, 2-page form, and the right person who already knows how to fill it out, you could have it done today. All right, see ya.